Dear clients, dear friends from Taylor Westing, welcome to our webinar, Get Ready for Brexit. We have a quick fill-in for you in the major points and areas of interest concerning the Brexit. We have a full range of experts for you this evening or this morning, depending from where you follow us. We have labor law, commercial, cross-border, data protection, and brands. And the idea is that you get a quick fill-in, 10 minutes each for the major point. So when the Brexit comes, 1st of January, in order to save some time, I'm your moderator for this evening, and I will really stop talking in a second. When you have questions, please feel free, hammer the questions to us. We will answer during this session, and everything which remains unanswered because of time, we will follow up later on. But now that's for the intro. So I first would like to welcome Jonas, our labor law expert. Jonas is talking about, is there an end to the free movement within the EU for UK citizens? So Jonas, please, your stage, 10 minutes, quick fill-in.
Excellent, thanks very much. I have the great honor to start off our webinar on the consequences of Brexit, and obviously also the current status of Brexit as it is. And one thing you will be hearing during this webinar very often is that Brexit actually already happened, effective end of last year, and that we are currently in the transitional period, which also has an effect on the questions I want to talk about today, which are the consequences for British citizens who want to live and work within Germany. And we need to differentiate between British citizens who currently already live in Germany and those who want to travel to Germany after January of next year. So British citizens who already live in Germany are a resident in Germany. My question now, how can I ensure the status? I don't want to be living and working in Germany illegally as of January. And the good news is that is fairly easy, and even during COVID times, this can be handled. So what do you need to do as a British citizen to ensure that you can remain a resident within Germany? You have to register, and that is based on the withdrawal agreement between the UK and the European Union, and it allows you to register as resident, and by that ensure the status until end of June of next year, 2021. As I said, if you have been a resident of Germany by year end, so by 31 December of this year, and even though no authorities have so far mentioned that explicitly, at least to my knowledge, it is definitely sensible to have some proof that residency in Germany has already been established before the end of the year. And that can, the simplest way to do that would be to have a registry certificate, which you can get from the city where you live in. Simply apply for that, and then ask them what is the city's way to allow UK citizens to register, because that very much depends on the city you are living in. For example, Hamburg allows for an online registration. I haven't gone through the process, but it mentions on the homepage that this only takes 5 to 6 minutes. So it is fairly easy, but it is necessary. And that allows you to remain a resident of Germany and to live here for whatever time you like. Those UK citizens who currently do not reside within Germany can travel to the European Union and obviously also Germany for 90 days out of 180 days as a rolling period without the need for a visa. So you can still travel visa-free. That partly answers the question, is this an end to the free movement within the EU for UK citizens? To some extent, yes, but to some extent also no. So you can still travel to Germany, just hop on a plane and come over here. You do not need to apply for a visa. What does change, though, is that at the moment, obviously, not as a EU citizen anymore, but during the transition period, you are also allowed to work within Germany without any further requirements. And that is the most substantial change as of January, because as of January, you will need a work permit, and you will need to apply for that. But the good news is that even though the law on this has not officially been passed yet, it's very certain that UK citizens, UK citizens will be able to apply for a work permit for any work you want to pick up. So you do not have to qualify as a skilled worker. You do not have to be on a secondment from the UK to Germany. You can, whatever job you feel like doing within Germany, you can do so. You do need a work permit, but you will also be able to get it. And that is a huge difference to citizens of most other countries in this world. And this is also not part of the law yet, but it's very certain that it will be as of January. You will also be able to apply for this within Germany. So most third-party country citizens will have to apply in their home country for a visa, then come here, transfer this to a work permit. For UK citizens, this will be different. You will be able to simply travel here, find the job you want to work in, and then apply for the work permit within Germany. So you do need the work permit, but again, it's fairly easy. We only have 10 minutes, so I need to rush through this a bit. The last point we wanted to discuss is in case a UK citizen decides to become a German citizen, what happens to the UK citizenship? So usually, if you apply for a citizenship within or a German citizenship, you would lose your original citizenship unless this causes some hardship on you, so there are exceptional cases, or you are citizens of any EU country. So any French citizens coming here applying for a citizenship in Germany will also be able to maintain their French citizenship. So far, obviously, that used to be the case for Brits as well. Will that change? The good news, again, is no, it will not. This is has also not been passed as final law, but it's very evident and independent of whether or not there will be a trade deal. British citizens applying for a German citizenship will be able to also maintain the British citizenship, so there will be a dual citizenship after all, also after or starting January of next year. That was actually all I wanted to discuss. And I'm actually a little bit ahead of time, which
This
is but jumping on
stage. Jonas, this is fantastic that you even are ahead of time. Jonas, thank you very much for your insight. Clap your hands for Jonas. And it seems to me that it's pretty easy the way from UK to Germany. Pretty easy, 5 to 6 minutes to maybe not become a German, but at least to work in German. So this way around, that's good news. The other way around, European folks going to UK is probably more complex. We need to ask Boris Johnson how that will work in future. But before we do that, please welcome Donata, who sheds some lights on an issue which is more a commercial issue. It's about deal or no deal anymore, Brexit and its risks for your business. So the business-related questions with the Brexit. We going to have insights now from Donata. Please, Donata.
Thanks a lot, Axel. So yes, I want to talk about the impact of Brexit on commercial relations. So what will actually change? What does it mean for existing contracts? And also what should you be aware of when concluding future contracts? So I think we all need to face the realistic scenario of a no deal. That means that all EU regulations will no longer be applicable in the UK after the implementation period, so as of December 31st. It might well be that the UK will incorporate some of the regulations into national law, and they did so already, but as I just said, they might. And so this shows already that there's a huge uncertainty as to what the law will actually be. And even if you have so-called EU retained law, so some regulations that were incorporated into national law, this might develop in a completely different direction, since the interpreting and decision-making power does not longer lie with the European Court of Justice, but with the UK courts. So the fact that the EU law does no longer apply in the UK has a huge impact on marketability of products, customs, and also when it comes to litigations. And I want to shortly touch upon these three topics in the next minutes. So marketability. In the future, the marketing authorization of products in the EU for pharmaceuticals, for example, will no longer be automatically valid in the UK and vice versa. The same applies to the CE marking system, which will no longer apply in the UK. So you need to make sure when you bring a product to the UK market that it complies with all UK requirements. And you will hear that a little bit more often today. We are not aware at the moment what these will be. Also, the UK will no longer fall within the EU product compliance regime and will be classified as a non-EU country, so a third country. So maybe the next example will show what that means. So imagine a distributor is selling products from Italy in Germany, and in case the product leads to personal injury, for example, in the first place, the Italian manufacturer will be held liable as the manufacturer. So when this distributor now sells the product into the UK, he will become the importer from a third country. And that means that he is responsible for the product's conformity, and he will also be held liable as a manufacturer. So in a nutshell, the legislative changes mean increased responsibilities and liabilities for many businesses. And it's very important to review supply chains and processes to ensure compliance of the products. The next topic, customs. So as you will all know, the UK will no longer be part of the EU trade union, customs union, but fall under the WTO regime. So that means custom clearance becomes necessary, and also custom duties needs to be paid. But besides that financial impact that requires extensive paperwork, and that again increases the risk of liability in case of wrong statements or missing statements. And last but not least, the customs clearance process may lead to delays, and especially when you concluded contracts before the Brexit referendum or the Brexit, and you were not aware of those delays, that they will occur. And this is the bridge to the next topic that might lead to litigation. So what will be the difference when it comes to litigation? First of all, there is a risk for you as a defendant of parallel proceedings. So in the EU, we have the Brussels I regulation, and that regulation states that when a claim is initiated in one EU country, a court from another EU country is not allowed to take the same case and assume jurisdiction. So it's not possible that two claims for the same case are filed in two different courts. That will no longer apply with regard to the UK. So it would be possible that someone issues a claim in the UK and in another country as well to see where he gets the better outcome. And this is actually the worst case scenario then, that you receive deviating decisions. But also from the other perspective, when you are a claimant, it might get much more difficult to serve a statement of claim. Again, in the EU, we have the Brussels I regulation, which makes it quite simple to serve a claim in another EU country. We simply do not know how that will work in the future in the UK and vice versa. And the same applies when it comes to the enforcement of a judgment. The Brussels I regulation makes it very, very simple how it will be to enforce a German judgment in the UK. We don't know yet. It will work, but probably it's more difficult. So what is the consequence for existing contracts? When we pick up the example of customs, for example, you concluded a contract, you didn't know that you have to pay customs, and now you have, and that has a huge financial impact and may even make your business unprofitable. So you can assess whether modification of your contract is possible. The first possibility is that you find some legal provisions that allow to modify the contract. For example, in Germany, we know the system of frustration, the so-called Wegfall oder Störung der Geschäftsgrundlage. So this says that when circumstances severely changed after the conclusion of the contract, it is under very strict conditions possible to modify the contract. The other possibility is to look into your contract, whether there are clauses that allow for a modification or even termination of the contract. So I talk about force majeure clauses, about hardship clauses, or material adverse change clauses. These clauses normally are very tailor-made, and you really have to look into it whether that is applicable for Brexit. And of course, I think all these possibilities are only possible when you concluded the contract before the Brexit referendum, because after the Brexit referendum, you could have known what's going to happen, or at least could have included some clauses in the contract that addressed these potential risks. What is always possible, of course, is try to renegotiate the contract with the contracting party. So it might be in the interest of both parties to amend the contract due to the new situation. Future contracts. So what should you bear in mind when you conclude a contract with a UK party? So first of all, rethink the choice of law clause. So when you had English law before, you should at least be aware that the EU law is no longer part of the UK law, and there's a lot of uncertainty as to what the law actually is. So maybe it's not the best choice, English law, but rather German law, for example. Then the shift of liabilities, as I said before, for example, the manufacturer who is seen now as the distributor, who's now seen as a manufacturer. So maybe you should incorporate into your contract indemnification clauses. You should also think about insurance coverage. these are all topics to limit your liability. I also want to address Inco terms. Inco terms are frequently used in commercial contracts, and they regulate who is responsible for duties, documents, and so on. And that might not even have been a big deal in the past, but that can now lead to substantial costs and efforts for the respective party. So you should take this into account when agreeing on an Inco term, or money-wise, but also time-wise, for example, when you agree on certain delivery dates. And last but not least, I highly recommend to incorporate an arbitration clause, because the UK is still party to the New York Convention, which makes it quite easy to enforce an arbitral award. And as I said before, as regard judgments, we simply do not know yet how easy that's going to be. Thanks a lot.
Donata, thank you very much. And thank you very much for all this information. I must say I'm really impressed that so many information can be put into 10 minutes. And for those who are now very stressed because they take down all the notes, please relax. We're going to produce a little checklist and brochure, which it will need a couple of days more, but we will distribute that afterwards. So please, everyone, relax, take a glass of wine and enjoy the show, and don't waste your time in taking down notes. So, Donata, thank you very much. Now we just move over to the next topic. The next 10-minute slot is with Lars, and we have cross-border issues, and Lars is talking about the challenges for the free movement of goods beyond December 31st, 2020. Lars, you are on stage.
Thank you, Axel. It may have been pushed a little bit in the background this year by the Corona pandemic, that but not long, as we heard already, Brexit will actually be completed. And it's not decisive at all whether Brexit will become a hard or soft one. The marketability of goods will be affected in any case. Some of the things were already presented by Donata. Now some additional thoughts from the regulatory perspective. It is certain that from 1st January 2021, the UK will no longer be part of the EU single market. It will become a so-called third country. And in contrast with Norway or Switzerland, the UK will not have special rules on participation in the EU's single market. This will lead, on the first, to increased administrative burdens and longer delivery times in the supply chain. Within the EU single markets, free movements of goods prevail. In particular, there are no custom controls within this market. As of 1st January 2021, the UK will also no longer be part of this EU custom union. This leads to barriers to border mobility in both directions from the UK to the EU. In future, goods will be stopped at the border, especially at the famous harbour of Dover, and inspected under customs law. It is to be feared that this will not work smoothly, especially at the beginning of 2021. Besides these changes in border traffic, the legal role of actors in the supply chain will often change. EU companies that currently distribute products coming from the UK will become exporters, or EU companies that currently distribute coming into the EU will become importers for products they place on the union market. And this means that they will need to comply with the obligation of an exporter or an importer according to the applicable union rules. In particular, if a company has no previous experience of trading goods with third countries outside the EU, this can lead to significant changes. So which products may be affected by Brexit? Initially, all products which are traded between EU and UK will be affected. Products imported into the EU will have to comply with the EU rules, and products exported will have to comply with the UK's, which we don't know at the moment. It is likely, but at no means certain, that the UK will seek to harmonize the rules as much as possible. But the changes described in the following will happen in any case, even if an agreement will be reached in future. One note at this point, for questions about the UK law, we also have a bureau in London. They will be happy to assist. The marketability of products usually depends on the person who places the product on the single market for the first time, bearing certain obligations. This includes products that are not suspected to be so, for example, any products that contains wood, even paper. In addition, there are products that are specially affected. These are, first, products whose marketability depends on the granting of certification of authorization, for example, cars. Certification with authorizations issued by UK authorities or by bodies based in the UK will no longer be valid for placing products on the union market. Second, products whose marketability depends on registration of products in a database. Where union legislation requires such a registration, this may have to be done by an importer in the union or an authorized representative of an UK manufacturer. Third, products whose marketability depends on real presence in the EU. The union legislation provides for the requirement to be established in the union for certain economic operators or other national or legal persons. An establishment in the United Kingdom will no longer be recognized in the union. And next, marking and labeling, for example, the CE sign, as Donata also mentioned. Markings or labeling of goods placed on a single market which refer to bodies or persons established in the UK will no longer comply with the union labeling requirements. This shall be illustrated by the example of the regulation for chemicals. As of 1st of January 2021, the REACH regulation will no longer apply in the United Kingdom. Registrations under REACH requires a seat within the EU. Registrations held by manufacturers and producers established in the UK will no longer be valid. These entities and their customers will have to ensure that substances are registered with a manufacturer or an importer in the EU or appoint an only representative in the EU as a registrant for the substance. Downstream users will have to check whether a registrant established in the EU registers substances they use. Where this is not the case, they should adapt first. The supply chain accordingly maybe identify an alternative supplier. Check whether the UK registrant they deal with plans to appoint an only representative in the union or register the substance itself. So how to ensure the marketability of your products? To ensure the ability to act after the 1st of January 2021, a worst case scenario should always be assumed. Doing so, first, check your supply chain, whether goods are imported from or exported to the UK. Check whether Brexit changed your legal role in the supply chain and further check what are the legal consequences of such a change. It is also necessary to check whether the marketability of goods depends on measures such as authorizations which have so far been exercised by UK authorities. If this is the case, it should be checked whether these authorities can be transferred to an entity located in the EU. Familiarize yourself, if not previously known, with the course of customs procedures. Familiarize also with future regulations on the British market and contact your UK contractors about how they plan to act in the future. Let me end with an outlook. Even now, we are in November 2020, but the future of Brexit is still unclear. But what is clear? On the 1st of January, the transition phase will end. It is further clear that the free movement of goods between EU and UK will end. And it's also more than likely that there will be no agreement between the UK and the EU at this stage at the 1st of January or next year. But all you can really do is make the best of this situation. First, be prepared, do your risk management, and especially review your supply chain and your contracts if you are affected by Brexit. Thank you.
Lars, thank you very much, and thank you very much also for the last comments where you said that something is clear. It was really like a positive and good surprise after all the uncertainty to have at least a few things where you can say these facts are clear. This is what we can rely on among all these big question marks we have. In particular, the very big one, do we have a hard Brexit, yes or no? It's quite amazing that although it's just 6 weeks ahead, we still don't know an answer to that very important questions. But let's move now to our next topic, data protection. One of my personal favorite topics in that area. Nothing in these days now can be answered without also reflecting the impact on data. And we have Christopher here, Christopher, who is going to talk about securing cross-border data protection post-Brexit. Christopher, here we go.
Thank you, Axel. And I'm afraid to start with more questions like my colleagues before me. Will there be a deal or will there not be a deal? Probably there will not be a deal. If there's a deal, what will this mean for data protection? Your guess will be as good as mine, I suppose. But we suppose there will not be a deal. There was the transition period also for data protection that will end of this year. There was the chance to extend this transition period, which of course was not extended. There are discussions about trade agreements. What would trade agreements mean? They would mean probably not much for data protection, as trade agreements tend to rely on the adequacy decision. So we will discuss what will happen in the case of a hard Brexit and what can you do about it. If there's a no-deal Brexit, this means that the GDPR will be applicable in Europe and for the UK as far as data is concerned with European connections. This means that there's a risk of fines. There's authorities that will investigate possible breaches of privacy and data protection. There's the normal rules that you would need to apply from GDPR. Can we expect maybe help from the European Commission? Probably they will not be able to give an adequacy decision just yet. They say they have indicated in 2018 that the current rules are sufficient, so they will not make any special exceptions for the UK. So what does it mean if normal GDPR rules apply? It means that the GDPR is applicable for Europe and it is applicable for companies in the UK that offer services to companies in Europe or process data of European citizens or that monitor European citizens. That is the normal rule that applies under the GDPR for any third country. It also means that the law that the UK passed on data protection will apply for the UK. That is the DPA from 2018, which is more or less a one-to-one copy of the GDPR. So that will apply in the UK for companies there. And because it copies a lot of the GDPR, it may be the situation that you will need to find compliance under the GDPR and also under the DPA 2018 if the data processing falls under both. So the consequence of this is the UK will become a third country, will be treated like any other third country under the GDPR regime. There's possible legal consequences for, let's call them illegal data transfers to the third country that are not secured. There's the risk of fines. And the question is, how much discretions will authorities have? That is what is going to happen. So what can you do at this point? First of all, I want to point out that it's very important to revise your data protection concepts. You already have data protection concepts in place, I assume, I hope. So revise those under the light that the UK will be a third country. Up to now, you would not have to think about international data transfers when dealing with the UK. So maybe your data protection documentation does not reflect that there is an issue coming up now. Because if you are a company situated in Germany, you have a subsidy in the UK, data transfers to the UK, data transfers from the UK. Before, they would not be seen as cross-border transfers. Now there's a whole new issue coming up. You may have to update your data protection concepts. And that concerns processing of UK data in the EU, as well as EU data in the UK. So the suggestion is to go in, examine what is happening with your processes, and see where there's need to update anything. Second of all, the important point is to review contracts and legal issues that you may have. You may have contracts, intercompany agreements, contracts with service providers that maybe do not talk about data protection at all. Maybe they're very old, before GDPR, maybe they were concluded in the last 2 years, but maybe there's no clause that will deal with the situation that's coming up. So see if there's need to update contracts. Maybe some contracts just need a short amendment to clarify the situation under Brexit. Maybe you need to revise it on a bigger scale. That very much depends on the processing operations, on the situation of the companies, which one is a controller under data protection law, which one is a processor. Those are all things to consider. And the third and probably most important point, and also the one where there are still some question marks, is how to secure data transfers between the two countries. So once you have your contract set up, you have your situation found out, you have your documentation, then you see GDPR requires you to secure international data transfers to third countries. So now that the UK will, in all likelihood, be a third country, how can you secure those data transfers? The easiest and best option would be an adequacy decision of the Commission regarding the UK. They did not have an adequacy decision yet, they did not reach it yet, and they have indicated last year that it will take around 1 to 2 years to reach the adequacy decision. So maybe there will be a surprise, maybe they will find the adequacy decision, but there has also been criticism raised about if the UK can even qualify as an adequate third country. It's basically the same argument towards the United States, where there's issues that are not resolved and the Commission is a little hesitant to issue the adequacy decision. If they really wanted to, maybe they would have done it till now. So we should probably not rely on the adequacy decision, which would solve a lot of problems. Second is, there are exceptions to the requirement to secure data transfers. I know some colleagues see this as a solution. They say, yeah, we have the exception for contract processing with consent. We can have international data transfers without the requirement for securing these. But I'm a little skeptical about that. In my opinion, those are exceptions that cannot be made to the rule. So maybe you can use that for individual transfers. Maybe in your situation, this can work out for some cases. I would not suggest to rely on them as the catch-all, the save-all means. And I don't know, but I can imagine the authorities will be very reluctant to use exceptions as solution for this problem. There are other guarantees in the GDPR, binding corporate rules. Those are rules that you have inside of your group company. There are approved clauses where an authority can approve clauses in contracts, approved codes of conduct and such, but these all require the supervisory authority to approve these measures. We have at Taylor Wessing tried some of these measures, and the authorities are very reluctant to approve anything because basically they're in the same situation. They don't know if this can work. We are waiting for approval for several of these clauses, and very likely you will not get this done in the next 2 months. So probably we cannot rely on these guarantees either. So this leaves one possible solution, and that is the most talked about, the standard contractual clauses. Those are clauses that were one time approved by the authorities. that then can be concluded between parties. They just sign it each other, send each other the signed copy, and then these contractual clauses are enforced, and they will secure the data transfer, given that you, of course, abide by the things that you agree upon. So why is that not the best solution for all cases? The SCCs, the standard contractual clauses, are only available for controllers in the EU. This means that you cannot use it with, for example, sub-processors. They are only what if you are the controller in the UK and have a processor in Europe? Then you cannot conclude them. There are also issues that you may have heard with the Schrems II decision of the European Court, where they say standard contractual clauses alone are not sufficient to secure the things. So examine your data protection setup, see where you are, see what you can do, if SCCs can be applicable. Otherwise, talk to your privacy expert, find a solution, maybe for the interim, maybe for exceptions. Talk to your privacy expert to find a tailor-made solution that is best for your situation. Thank you very much.
Thank you very much, Christopher, for your insight in the data protection area. And I quite like your advice at the very end, and I like your little column, a picture saying talk to your privacy law expert. So everyone is welcome, of course, if there are more questions ahead, to talk to our experts in that area. And as Lars mentioned, by the way, we have, for those who don't know that, one of our main offices is in London, and we have our London colleagues there who are absolutely delighted to assist as well with respect to questions coming up and who are UK related. And with respect to the adequacy decision, I just would like to mention, Christopher, my personal feeling is that there won't be certainly an adequacy decision. It will take at least a year, I think, and we will have a gap scenario until then, because no one knows where Great Britain is heading to. If they want to decide to be Cayman Island style a country, then the data protection niveau will go down and there's no room for adequacy. So by no chance the EU can allow adequacy just quick out of the box. It will be a process. But now we move to Wiebke, to our last 10-minute topic and slot here. And it's all about Brexit and brands. And interestingly enough, Wiebke says in her headline, brand owners to-dos before December 31st, 2020. And that's really news for us, because everything we talked about was a little bit like, well, let's see where it's going to, and then let's check what we have to do the following 31st of December. And now Wiebke is turning it the other way around. She only gives you another 6-7 weeks prior to that date to get your ducks in a row. So Wiebke, please go ahead.
Thank you very much, Axel, and good evening, everybody. And it seems that with the brands topic, there are a couple of differences what you're facing compared to the issues we've been discussing before. First of all, I can assure you that it won't make such a big difference if we get a deal or a no deal, because the UK has already enacted legislation in relation to trademark law that will give them a regime to the trademark situation that will be pretty similar to the situation we're going to have if there will be a deal. So I think that's quite different from what we heard before. Secondly, I'm also pleased to be able to give you some good news. Registered European trademarks will be automatically transformed into a so-called comparable UK registration. So for all of you who are brand owners, who are owners of EU trademarks, and also who are owners of EU registered designs, which for the time being do cover the UK as a territory, you can be sure that the UK territory will also be covered in the near future for the remaining validity time of the EU trademark or your registered design. So how does it happen? On January 1st, 2021, the EU trademark, or the UK part of the EU trademark, will be automatically transformed into a so-called comparable UK registration. And this comparable UK registration will be transferred into the UK trademark register. So whatever you've got here at the moment from registered designs, they will continue to be alive in the UK for their remaining period of protection time. So this also means if you have pending trademark issues going on with EU marks at the moment, so for example, if you've got an application running which is being opposed, or where you're having negotiations with potential opponents, it is highly advisable to do everything to settle the dispute and get the trademark registered, because once you've got the EU mark registered, as I said, you will be entitled for the comparable UK registration. If you have a EU trademark pending at the moment and will not get it registered till the end of December, you do have the chance to refile it in the UK if UK protection is required. So for all trademarks that are still in the application process, all EU trademarks that are still in the application process, do have a close look if you need protection in the UK. And if the answer is yes, make sure to file the application in the UK, and so to guarantee the protection period. The good thing is also here we've got a so-called we've got a 9-month period till the end of the transition period. We've got till the end of September 2021, and during this time you can claim the priority of the EU mark, as well as the filing date and seniority dates. And this means that, for example, if you filed for an EU mark in September and this mark hasn't been registered yet, when you file for the UK application in January or in April or in August, you can still demand that the application date of your EU trademark, which was September 2020, will be part of the EU registration. So by this you can kind of buy extra time and you can use the priority of the pending EU mark. For the moment, if you need a trademark but you haven't filed for an EU mark yet, and you are also sure or you think it's likely that you need UK protection in the future, from anything starting from today, we would recommend to file both EU trademark as well as a UK trademark, because this guarantees that you will quickly have protection in the UK. And this may, for example, be necessary if you've got licensing purposes, if you need to enforce claims. So if anything, if you don't have a pending EU trademark already, I think it makes sense to, for the future, file both EU marks and UK marks if you need the UK territory. So what else do you have to care about, and what else can you care about already? If you've got agreements going on, if you've got license agreement, if you've got differentiation agreements, do have a close look at them if you haven't done that yet, and see if the wording is clear and if it can be argued that they will also cover UK trademarks in the future. If this is not clear, you should get back to your contract partners and align the agreements and make sure that your joint understanding is that also in the future UK marks and the UK territory will be part of the license agreement or any other agreements you have made relating to UK trademarks, to European Union trademarks. Another issue which you should have a look at is if you've got pending or threatening infringement actions. Infringement actions that are filed before December 31st still can rely on the old regime. And for example, if you file infringement actions based on a EU trademark, which also covers the territory of the UK, it will also have an effect on the territory of the UK after the 21st of December. However, and that's hugely complex, there may be issues when it comes to counterclaims where you should decide carefully whether it makes sense to still file litigation till the end of the year, or if it makes more sense to file the litigation, for example, just based on a UK mark in January. And it would go too far to discuss this in detail, but if you've got any issues, do have a close look and ask for advice so that you can make the right choice, whether already now you're still going to file based on a union trademark, or if you should better file based on UK trademark to claim your rights or to defend your rights. Another issue which is important for you to know, and where you should check the status of your European Union trademarks, is who is your advisor on record. Most people, most trademark owners have representatives, either law firms, sometimes they also have employer representatives. And if you've got a representative on record that is based in the UK, for example, a UK firm that doesn't have any further offices in the European Union, make sure that you get a representative who is based in the EU. Otherwise, your former representatives will no longer be able to help you and to support you in this matter. And you will also have difficulties with your communication, so make sure that you've got an EU-based representative on the record for communication with your EU marks. Another advice I want to give you for the time after December 31st is check your lists, check your trademark lists, check your records, because then you will have to duplicate whatever you had now with EU trademarks. As I said, you will get automatically for registered EU marks, you will get a registered a comparative UK right, but you might not have this in your lists already, in your data, in your system for reviewing your trademarks. And it is quite a risk that if you just duplicate the mark but you don't register the new deadlines, because in the future, although your UK trademark will need to be monitored and you will have to have your filing dates and the end of the protection date on your lists. So do make sure that all data is carefully duplicated also for the future comparative rights. And another thing which you need to consider in the future is review your brand strategies and, for example, also your brand watches. If you've got a Europe-wide protection or trademark search in place, if you've got the review in place, which is based on EU member states, make sure, and if the territory is relevant for you, that you will also have the check for national trademark rights, UK rights in the future, and that this is added to your watch list. And well, that's basically it. Axel is already looking at me, and as I said, you can take a deep breath, and there's a certain relief that you don't need to do a lot to your union trademarks at the moment. But of course, you will need to monitor the process and make sure that you won't lose any rights because they just fall off the radar.
Thank you very much, Wiebke, for your very thoughtful summary of to-dos in the brand area. And as Wiebke said, that's why I'm laughing. I have that, I don't know, not so nice role here. Always when I appear on screen, that means time is out, and folks know that they have to get ready, because we are very strict on time, but we still have, let's say, 4 or 5 minutes to go altogether, so we can have a little discussion about some topics. And I have one question for our regulatory experts. So that could be either Lars, that could be Wiebke, that could be Christopher. And the key question is, from the German regulatory side, are there any signs of, let's say, grace periods or interim periods for companies so that they have a chance to kind of adjust whatever comes 1st of January 2020? Are there any 2021? Are there any indications? Have you heard about something like, well, the first 3 months we take it easy and then we go against, or is there silence? That's an answer. There seems to be silence. It seems to me that you haven't heard about it. If so, please chime in and just say, no, our authority said you can have a deep breath and a nice sleep for another year before we get active. But my feeling is, and that's what I heard, no one really has an answer here.
Yeah, well, I can just say for the trademark side, Axel, as I just said, it's quite clear. It's you can be relaxed till the end of the year, and then you have to take care of your matters. But there's no, it's quite clear. It's either it works or it doesn't work.
Well, given that we are in a transitional period actually right now, I'm not sure if they will give additional transitional periods for data protection. We are in the year that should have been transition to something clear, and the authorities have indicated that the rules are clear. They see the rules as sufficient. There's no need for special treatments from their perspective, and the UK will just be treated like any other country.
Yeah, and I think that's the main point. There already have been 1 year to prepare, and now Brexit is getting final.
Yeah, that's a good answer, Donata.
I just wanted to say it's maybe the other way around when it comes, for example, to the CE marking. It's that the UK government said that CE marked goods can continue to be placed on the UK market until end of December 2021. So it might be sometimes the other way around, that the UK try to push business that you can place products in the UK that come from the EU.
Yeah, so the only good news is here that those who listen to us this evening, you're not alone. Very, very many, if not all, companies are facing these issues. We will have multiple questions to solve, and there will be life goes on, and I'm quite sure that we all together managed to come over these hurdles. And my final question here is, and I would like to address this to Christopher, because Christopher is a US citizen or US German, so he must know what's going on there. It seems to be that we have another president which was unexpected, probably from Boris Johnson. That's Joe Biden. He's Irish. He's very different from the former or still their president. What do you think, Christopher? Does this has an impact to the Brexit?
To the Brexit, I don't think that has any impact. The Britons have their own mind, and they did make up their mind, and I expect they will follow through what they started. Okay,
that's a hard word. I thought you may say, well, there are signs of a soft Brexit because of the problem in North Ireland and because of the new environment in the US. But now this is what you said. There will be no change in it. Still amazing that such a very, very important question like the Brexit is unanswered just a second before that starts, with all the issues for the companies, for the citizens. In my eyes, this is really unresponsible. But I mean, what can we do? I'm sure we're going to manage to overcome the stress and hurdles we have here. So there's no reason to panic. Everything is solvable, and as we said earlier, we are very happy to support you in solving any issues which are popping up. We check the questions. If there are any questions we haven't answered so far, we are going to do that afterwards. And as I said earlier, we will put together all information we had, who had been very, let's say, dense and only 10 minutes blocks in a kind of checklist. And we will distribute these checklists to those who listened to us this evening, so that you can go through that list one by one. Thank you very much for for listening, for watching our webinar on the Brexit. Have a nice evening and see you soon. Bye-bye. Bye-bye, everybody.